Why not just have a will for less money? You might be asking this question to yourself, but I'm here to tell you why it might not be a good idea. Hi, I'm Nick Carroll, an estate planning attorney here in Florida, and today we're going to talk about why a will may not be enough for your estate plan. First, what is a will? A will is a legal document that outlines what happens to your assets when you pass away. You can nominate someone called the personal representative or the executor to be in control of the process when you're gone. You can also use it to state your funeral wishes. If you have special instructions like burial, cremation, or something else, you can state it in a will. Although a will is better than nothing, one of the main drawbacks of a will in Florida is that it basically guarantees probate. Probate is a court case that happens when someone passes away with property or assets titled in their name only with no beneficiary designation. Probate can be a lengthy process. Sometimes it takes more than a year for it to be fully resolved, and it's also very expensive. Probate fees in Florida can range from 3 to 6% of the gross value of the estate. So if all your assets, your house, your bank accounts, your retirement, whatever is going through probate, if it all adds up to $500,000, for example, you would have to pay roughly anywhere between 3 to 6% of that $500,000, which on the low end could be between $15,000 to $20,000 in probate fees. The fees could even be higher if your attorney charges hourly and the case gets complicated, beneficiaries start fighting, or creditors start fighting. In addition, with a will, it's difficult to plan for beneficiaries who may need some extra help managing their inheritance, like minor children, individuals with special needs or disabilities, individuals who may have gambling problems, drug addictions, financial problems. With a will, it's difficult to help those people because at the end of the probate, they'll get their inheritance outright. And sometimes, depending on the situation of the person, it can complicate things for them. A revocable living trust is a common alternative to a will in Florida. It's commonly used to avoid probate completely. As we discussed, many people want to avoid probate because it's expensive, it's stressful, and it's time consuming. The trust allows you to do that. Additionally, the trust allows you to keep your estate planning and what happens to your assets private. Unlike a will, which has to go through probate court and which will eventually become a public record. So everyone knows what your kids inherit, and sometimes that can invite problems. Additionally, a trust can be useful because you can help to manage and guide the distribution of the assets owned by the trust. For example, if you have a minor child, you can leave instructions for how you want your trustee to manage the minor child's inheritance until maybe they're old enough to manage it themselves. Or if you have children who are financially irresponsible and you know if they get their inheritance directly, they're gonna blow it, or it might do more harm than good for them, you can put it in the trust, nominate a trustee who will manage the inheritance according to the rules that you leave behind. And some people condition the payment of the inheritance on achieving certain milestones like graduating college or getting married or whatever is important to you. Some people do it by age, so there is a payment at age 25, 30, 35, and so on. I even had a client recently who his trust says that his son's trust distribution should be calculated based on his son's tax return. So whatever income his son earned for the year, the trustee will match that income with a payment from his son's trust fund. The bottom line is a trust is much more flexible than a will, and it allows you to help guide how the inheritance that you're leaving for your beneficiaries is used and managed over time. Additionally, unlike a will, which only takes effect when you pass away, a revocable living trust is set up during your lifetime. So we can set the trust up for you. Your assets are transferred into the trust while you're alive and healthy. You're the trustee of the trust, which means you're in control of everything once you're alive and healthy. If, God forbid, you become disabled or incapacitated, whether it's because of an accident or an illness, or what I see a lot in my practice is Alzheimer's and dementia. If you're in any state where you can't make your own decisions and you need someone else to help you, with the trust, your successor trustee who's named in the trust can help to take over the trust while you're still alive and manage it for you without having to go to a guardianship court. Is it worth the extra money to have a trust instead of the will? It really depends on your situations and your objectives and what matters to you. If you want to avoid probate and the stress and expense that goes along with it, if you want to maintain your privacy, if you want to help your beneficiaries manage and guide their inheritance when you're not here, if you want to give your beneficiaries protection from creditors, I would strongly recommend that you consider including a revocable living trust as part of your estate plan. I like to think of it as an upfront investment that your loved ones will benefit from later on when you're not here. And if you've ever been a part of a probate case, I'm sure that you will understand when I say your family members will thank you for taking the time to put together a well thought out plan so that things are easier for them when the time comes. A will is not enough. Trust me. If you want to set up a trust as well, click the link below and set up a free, no obligation consultation call with me.